Welcome everyone, this is Amer from UCouncil. Today we'll talk about the process of going through job postings, attending job interviews, and then receiving employment offers. And the idea is that you understand some of the basic legal concepts so you understand the process, understand your rights, and then appropriately deal with circumstances as they may arise. We start always with our disclaimer that this course is not legal advice, so if you have any specific questions, you must contact a lawyer or a paralegal. First thing you want to keep in mind is that whatever employment you obtain in Ontario or elsewhere in Canada, there is a certain legislative framework that surrounds that employment relationship. And so what I want you to remember is sort of 5 basic legislation that will relate to your employment relationship at one time or another. And these legislations are, number 1, the Canadian Human Rights Act. This is a federal act for employees or for employers who are federally incorporated. So if you work for a federal employer, then the Canadian Human Rights Act will apply to your circumstances. If you are an Ontario employee, then the Human Rights Code will apply, and then if you are an employee elsewhere in another province or territory, then the human rights legislation for that province or territory will apply. If you are a non-unionized employee in Ontario, then Employment Standards Act is another legislation that contains a number of rights that you're entitled to, and those are specified in Employment Standards Act. Canada Labour Code is again federal legislation for employees who are employed with a federally regulated company. And finally, the Labour Relations Act is for Ontario employees who are unionized. In addition to the legislative framework, you must understand the policy framework. So legislation comes on top, and then there are specific policies that may apply in your specific employment circumstances. So if you are a unionized employee, then unionized employees have collective agreements. These are contracts between the union and the employer, which have very detailed clauses about what an employee can do, what are the hours, how do they get benefits, how do they get scheduling. All those kind of things are specified in collective agreements, but that applies to unionized employees only. If you are a unionized employee, then you must go through your collective agreement and understand it. If you're not a unionized employee, then it's not relevant to you. Second important policies that you want to look at are employers' workplace policies. And when you sign up, when you join a company, you're often given an employee handbook or workplace policies, or given a website that contains all those policies. And it's a good idea always to review all those policies in detail, because those policies govern your conduct, your rights, your obligations in that with that employer. And so you must understand those. And I think also, if you are with that employer for a while, let's say for a few years, it's always a good idea to review those policies from time to time to see if there are any changes, and keep those policies in mind, because these policies are always very important. The third policy framework are the industry-specific practices. And what I mean by that is, if there are no direct policies, workplace policies at the employer that may deal with an issue, then there may be certain industry practices that you need to follow. An example could be, for instance, if you're in automotive sales, and in automotive sales, if there is a process of how the regions are specified, or how the commissions are paid, and at what time, and how are the invoicing done and whatnot, there may be some well-known industry practices that many companies follow. And so absent any employer workplace policies, then you can rely on industry-specific practices. And then if there is a dispute, you can bring this to a judge, and the judge will take industry practices into consideration. So legislative framework is important, then the policy framework that you must keep in mind. Now let's jump into job postings. Job postings are usually pretty straightforward. You see them in Workopolis and Indeed and in the newspapers. They specify what is it that an employer is looking in a candidate in terms of experience and in terms of qualification and whatnot. So, but there are a few things that you must keep in mind when you're reviewing job postings, right? So job postings must not be discriminatory, in the sense that they should allow everyone, regardless of their gender, race, ethnicity, origin, as long as the person is qualified, is allowed legally to work, then it should provide equal opportunity for whoever is applying. And you will notice from many job postings that job postings at times say, oh, so-and-so employer is an equal opportunity employer. So they're sort of taking a step further to ensure that you understand that the posting is for everyone to apply, and there's no preference over one person over another on the basis of human rights code. The preference could be based upon, obviously, on the qualifications, but not based upon factors that are discriminatory. So non-discriminatory criteria is often laid out. If it's not, it's implicit. And if you notice anything in job posting that states otherwise, then that's a cause of concern. Now, in some circumstances, there may be discriminatory criteria that is actually allowed in law. So an example could be if there is a disability clinic that provides services to everyone who is disabled, and then if they decide to hire specifically people with disabilities, then that may be a situation where discriminatory criteria may be permitted. But generally speaking, the criteria for job posting must be non-discriminatory. Pay equity is another issue which is quite significant, still not resolved in Canada and in a lot of other countries. But pay equity is something that to keep in mind. There's a legislation called Pay Equity Act, but that is very specific to, I believe, federal or provincial employers. I believe only federal, but does not apply. What you must understand is it doesn't apply to private employers. And so you want to understand what is their concept of pay equity. Is it obvious in the job postings that they're treating everyone equally regardless of their gender with respect to remuneration, or are there different criteria for that? So these are some of the things to look in the job postings, obviously, in addition to whether you fit the criteria of qualifications and expertise that is being sought. So let's say you apply for the job position, you get an interview, and now you're attending the interview. There are obviously questions that an employer will ask that will confirm your qualifications, your experience. They will review your resume, will talk about your past experiences and whatnot. But at times, the employer may ask inappropriate questions. And inappropriate questions are questions that are discriminatory, that are questions that relate to issues that are prohibited in human rights code, and then the employer is trying to get a sense of that, primarily for its own benefit. So I'll give you an example, and that may explain it better. A lot of young women have these issues, and we get these complaints all the time, and we file human rights complaints for that, where an employer is trying to gauge whether this particular person, female employee, does she have young children? Is she planning to have young children? Because if a woman is planning to have children, then she may apply for parental or maternity leave and may be away from employment for about 10 months or a year or so. And, an employer may not be, very comfortable in accommodating that kind of situation. So what oftentimes they do is they try to figure those things out even before they hire the employee, so that they're not in a position to accommodate that person. Quite discriminatory practice, happens quite commonly. And so, and then there are very subtle ways that the employer will go around asking those questions. Obviously, the simple question could be, are you married? Do you have kids and whatnot? And those are obviously very discriminatory questions. But some of the ways the employer goes around those questions is by asking, hey, what do you do in the evenings? How do you socialize? How do you spend time? And trying to figure out from there, whether you have a long-term relationship, whether you have any children or not. Because if you're hanging out with your friends every evening or on the weekends, then you may not be in a relationship where you have children, or you may be expecting children. So all those kind of questions are inappropriate. And so we often get this question that how do you handle those kind of inappropriate questions? I mean, it's a tricky thing, because you can obviously call on the employer and say this question is inappropriate. I'm not comfortable answering that. But then the challenge is, if you still want the job, then how do you handle the question without actually not responding to the question, but still being tactful? So the answer is really that you look at the circumstances, you think about whether this is the kind of employer you want to work for. Because if the employer is showing signs of discrimination right at the outset, even in the interview process, do you want to have a long-term relationship with that employer? But having said that, if you still want the employment, then obviously you deal with it tactfully, and then you do not give away answers that may lead them to believe one way or another. You don't need to lie about it, but you can be tactful. You can be a little bit evasive in terms of answering those questions, and then the employer may get the message to back off. So there are ways to handle those questions, and obviously you have the option of saying that you're not comfortable and then just do not answer those questions. So one more thing in the modern world that I want to sort of raise it with you is that yes, the employer can ask these questions, and often do ask these inappropriate questions at the interview stage. With the modern technology, with all these social media websites, a lot of employers are not even getting to the stage where they need to figure this out. They'll just simply go to your Facebook or your LinkedIn or your other social media accounts, and then most people have their lives on those social media websites, and it's very easy to figure out someone's relationship status or children and whatnot. And so these decisions about the selection of who gets to the interview may take place even before the employer calls you for an interview, and just simply going through your social media. And it is absolutely very, very common for an employer to go through social media websites of potential candidates. It's actually become, in fact, a routine practice for employers to do that. So if you're looking for a job, if you want a certain career, you have to be watchful of what you put on the social media websites, because they absolutely have an impact. So you can use those social media websites to have a positive impact on your job, or they can diminish your chances of seeking an employment, even though you may have excellent credentials otherwise. So something to be careful about in terms of the social media context. Now, in terms of remedies, if you are asked an inappropriate question, and by that I mean question that's discriminatory, something about your age, your marital status, your sexual preference, all of these things, your ethnicity, your religion, all these questions are prohibited in an interview. But if an employer does ask you those questions, then you have, in addition to saying that you're not comfortable in answering those questions, you actually have the ability to file a complaint with the Human Rights Tribunal or Human Rights Commission, depending upon whether you're in Ontario or in a federal jurisdiction or in another province, and file a complaint for discrimination, and you can get remedies through that process. So something to keep in mind, or you can commence a court action. So you can seek legal advice and then proceed. But if you're really looking for a job and you want to work for that employer, then you may have to be tactful in getting into the workplace and then getting the job there. So let's say you pass through the interview process. Now you have a job offer in your hand. So the single most important thing that you want to keep in mind, look in that job offer, is the termination clause. Not your salary, not your hours, but the termination clause. That's the single most important thing, because we have spoken about this on a separate lecture. You can go through our channel, and there's a whole lecture about contracts and the termination clauses. So I'm not going to repeat that here. But this is single most termination clause is the single most important thing, because in your lifetime, in this day and age, you will go through a number of employments in your lifetime, and you will be let go from employments regardless of how good an employee you are, just because of the economics of it. And the termination clauses will be triggered, and that will decide what benefits, what rights do you have on termination. And you could have significant rights on termination if the termination clause is not in your contract, or it's drafted in a way that it benefits you most. So that's the single most important thing. Second most important thing is the clause about restrictive covenants. And again, this is included in the separate lecture. But restrictive covenants are issues that the things that you're not allowed to do even after your employment has ended. So restrictive covenants control your action even after your employment has ended. So you want to make sure that you understand those clauses and you're comfortable, you're agreeable with those, because even when you end employment, you're no longer with that company and you still are not able to do certain things. So it's important for you to know what are those things. One thing that I want you to keep in mind is that once you sign the contract, once you sign on that dotted line and you give it back to the employer, then you have a binding contract. You are bound by it. So the start date may be a week from now, a month from now, but the contract, the moment you have signed, you're bound by it. And why it's important is that if you are unsure about any clauses, if you're not clear about anything, you want to talk to an employment lawyer or anybody else to understand that prior to signing it, but once you sign it, that you're bound by that contract. And secondly, oftentimes we're posed this question that, look, I signed a contract and now I have another job offer. Can I just leave that one? I haven't started there and then go and join another company. Well, the answer is yes, you can go join another company, but you are actually in breach of the first contract. So most employers won't care, but some employers would, and they will come after you for the breach of contract, and then they may seek damages. So be mindful of that. We have done cases converse to it. So in one situation, we had a pharmacy manager who came to us who had applied for a job in another pharmacy, got the job, signed the contract. The start date was a month from then, and then he resigned from his existing position. And then at some point in between that time, after he resigned and before he began employment at the next place, the new employer contacted him and said they're rescinding the offer. And so when he approached us, and we said, no, it will be a breach of contract. They cannot just simply rescind an offer because it's a binding contract. And so we had to sue that employer and seek damages. So signing the contract, the act of signing is important. Once you sign it, then you're bound by those terms. So hopefully this was beneficial in terms of the hiring process, the job postings. It gives you some sense of what your legal rights are. If you have any questions, if you have any specific topics that you want us to cover, by all means contact us and we'll cover those in our future lectures. Thank you for watching.